título de mi intervención, de la ponencia,
The title of my speech, of what I want to tell you, is as follows: a model of international law and of the UN Convention on the Law of the Sea. It's not my title, actually. It's a title that was suggested to me by the coordinator of this seminar. I congratulate him and his team, in fact, for organizing this. I thank him as well very much for inviting me so kindly. And the title that I accepted, well, the convention and its pretension of universality and generality, is one that's, well, it's a great pleasure for me to try and tackle it. I'm going to try and develop more or less the ideas that Giuseppe Cataldi and José Manuel Solverino, also Carlos Domingo, have already more or less put on the table. By the way, it's a great honor to see you once again after such a long time. Anyway, with this convention, with the UN Convention on the Law of the Sea, after many years of work, as Professor Pastor Ridruejo has mentioned, the negotiating delegations and the negotiating parties themselves, Daniel Vignet amongst them, and as I've said, playing a specifically relevant role, they were convinced that with this, with the convention, they would be able to establish a legal scheme and framework which would be generally accepted and which would have a long life, a global treaty that would tackle basically all the aspects regarding utilization, uses, resources in the oceans, etc. Despite of this, the UN Convention on the Law of the Sea took a long time to enter into force, 12 years actually. It entered into force on the 16th of November 1994. And the majority of the contracting parties at the beginning belonged to the developed world. It was significant to mention the important African participation and the scarce European participation, limited basically to Iceland, Malta, and the ex-Yugoslavia. But a few years after its entry into force, or more or less at the same time of that entry into force, ratifications and adhesions grew up considerably, including adhesions and ratifications by developed countries. The direct cause behind this new situation was no doubt the sort of accommodation or subordination, if you want me to say so, of the original solidarity-based ideology in terms of how to manage common world heritage by the General Assembly of the United Nations. In 1994, the General Assembly passed on an agreement having to do with the 12th part of the 1982 Convention, as you know, and it has to do with that. Today, the UN Convention on the Law of the Sea involves many countries. There are 163 states that are party to it, and the European Union is one of those. And bearing this in mind, also if we use the concept of interested parties, I think that the great absences, to say it somehow, in the Convention could be counted just with our fingers, basically. The continent with more non-present countries is one with 15 countries, and also it is significant to mention Iran, Israel, Turkey, which are not part of the convention for different reasons. In Africa, there are 8 countries which are not a party to the agreement. In South America, Colombia, Venezuela, Peru, and particularly also in North America, the United States of America is a significant non-presence in the convention. In Oceania, all states are members, and in Europe, many are part or to the contract, to the convention. Only a few are not part to it: Andorra, Liechtenstein, and Azerbaijan, basically. With regard to this, it is quite significant to point out that if we look at the 32 states which are members of the United Nations and that are not part of the convention, yet 13 do not have any coastline, and 4 are coastal states but with closed seas. The United Nations, through its General Assembly, is every year insisting on the objective of reaching a universal participation towards the 1982 Convention. But at the same time, it asks the countries, the states, to reach this goal of universal participation. It asks the states that, with regard to the 1982 Convention, that they respect that, and they respect the 1994 agreement as well on the implementation of the Convention provisions regarding highly migratory and transzonal species. The 1994 agreement is about to reach that universal participation, but the second one, the agreement in 1995, is not yet managed to do so, at least now. The 1995 agreement on Part 11 involves 142 states in the European Union. This agreement, which involves the formal application of the 1982 Convention, was adopted with the positive voting of 121 states, no voting against, and 7 abstentions. But in the voting, there were 55 states that did not take place. Small, tiny countries, half tired, half concerned, as Vinje would say. And well, today we have 21 countries that are left aside the Convention, at least today, that are left outside the 1994 agreement. There are countries like Egypt, for example, which are quite striking: Ghana, the Democratic Republic of Congo, Grenadina, Santo Tomé and Príncipe, etc., etc. Res inter alios acta. But what's the legal framework? What's the legal scheme behind this that's applied to these states, which are also members of the International Authority of the Seabeds? If we look at the force of the facts regimen, we have to take this into account. The 1995 agreement on transzonal species has been more limited. Today, it has several parties, which include the European Union and its 27 member states, apart from other 5 states which are part of the European continent. So, amongst those 79 parties, 33 belong to the old continent. The states in the American continent which are not part to it are 24. In Africa, we could talk about 41 countries not party to this agreement. In Asia, I think that it's quite relevant to mention or to highlight the absence of the highest fishing power, China. So, when we look at all these non-parties or absences, it is important to highlight that the 1995 agreement on straddling and highly migratory species is probably something that states that we should try to crystallize practices which are being formed. With the 1994 agreement on the 11th part, well, numbers of figures also state facts, but in this case it is different to the situation of the 1995 agreement. In the case of the 1994 agreement, some new regimen is working to say it somehow. If a new, if somebody accepts, it happens in the case that somebody accepts a representative majority of the international presence. It seems obvious that a treaty which obliges nearly 3/4 of the states that form the international community, it's clear that this should exert an inevitable influence on the law applicable to the others, and particularly if it is a treaty like the 1982 Convention, which obliges, at least conventionally, more than 4/5 of those states. But in this case, we could also state that, leaving aside inherited regulations, the Geneva agreements, etc., etc., we are facing providing an instrument, a tool, which has established that the international law is general and is a norm and has generated practices which are part of the general international law today. It is possible to find in the 1982 Convention some provisions, substantive provisions, I mean. Do you think it is possible to find some of these provisions which do not have a customary character? I think that it would be very difficult to prove this, because the forming of international law generally requires a general conviction. It doesn't mean unanimity. It is not an arithmetic problem. It is a problem of representativeness. In fact, the most significant absence in the Convention is that of the United States of America. The United States acknowledges publicly that most of the provisions within the Convention translate the international law which is currently in force. These provisions, on the other hand, are applied and implemented generally by the United States of America. Obviously, if the United States is not a party to this instrument, to this convention, it will not be able to become part of the institutional framework which has been created. This means that it won't be able to be a member in the states parties to the conventions and their meetings, in their meetings of the International Association for the Seabed. It cannot propose or suggest judges or any other nominees to form part of the International Tribunal of the Seas, etc., etc. The Convention, as we have said, against this proof to the contrary, translates the international law that's applicable to all. It is another big instrument, the result of the progressive development and codification of international law, like the Vienna Convention in 1961 and 63 on diplomatic and consular relations, or like the convention adopted in Vienna in 1969 as well, in terms of the right of the treaties. Nobody's going to argue that the provisions of this 1969 convention on the rights of the treaties, nobody's going to argue, at least in terms of substantive provisions, nobody is going to argue that this is international law in this matter, although after 40 years, it only counts on 112 parties members to it. This convention also, the 1969 convention, has also required a development, like, for example, we can see in works carried out by the International Commission that has to do with the rights to treaties. But it is, well, like in traditional diplomatic law or traditional consular law, it is a sector that's not so dynamic, or we're talking about sectors that are not as dynamic as the law of the sea. In fact, the Convention on the Law of the Sea was more a convention having to do with progressive development than these other conventions I've just mentioned. There was a big evolution between the big two conferences, the first UN Convention on the Law of the Sea and the second and third one, but the world has not changed. It has not stopped evolving. It has not stopped creating or introducing new situations, like, for example, the current Arctic situation, or introducing, for example, new concerns like we could say a mélange de facteurs, a mixture of factors which lead to the deterioration of the marine environment, generally speaking, including climate change. Just to give you a fact about this regarding maritime transport, for example, according to the data provided by the UNCTAD, the global merchant fleet has increased in just 1 year. The period comprised from 2010 and 2011 has increased by 120 tons of gross tonnage, which represents 120 million tons, which represents more than 8.5% only in 1 year. This means that the law of the sea has to continuously face new problems, new challenges that appear all over the world. Also, it has to face the problem or questions which perhaps were not known when the Convention was elaborated in 1982, like, for example, the issue of biological resources in the seabed, far beyond the national jurisdictional limits. Also, at the same time, there are some provisions of the Convention which require an obvious development. For example, this is a task that the 1995 agreement has deployed, for example, in terms of straddling and highly migratory species. Also, the FAO has worked a lot in the field of IUU fishing to try and develop chapters that refer to this in the Convention, or also the Convention of Paris, the Paris Convention in 2001 on subaquatic cultural heritage. There are numerous international and universal instruments, regional instruments as well, which refer to the protection of the marine environment and which are somehow a way of developing the Convention. This regulatory development, in fact, has been more or less elastic, to say it somehow, depending on the sector of the law of the sea we're talking about, because not all the parts of the 1982 Convention share the same proportion in terms of, well, some of them are more clearly stated or express more nuances than others. So sometimes we can talk about a codification or a regulation by the part of the Convention which is insufficient or not. But sometimes we can also talk about a codification which is inaccurate, to say it somehow. For example, this happens with the definition of marine scientific research per se, which does not appear in the Convention. Although a chapter is devoted to it, there's no definition or the baselines to measure territorial seas, for example. We talk about breadth, etc., but it's not specified in the Convention. There are also parts of the Convention which could be qualified as lifeless parts. Part 9, for example, devoted to cooperation between states bordering closed and semi-closed seas. Anyway, all the things that the Convention includes in terms of fishing or environmental issues, for example, I think it's not sufficiently developed. This is why I think that the Convention should be duly applied by means of the International Convention at a universal and regional level, but also by means of the national legislation applicable in each case. On the other hand, the Convention provisions must be adapted to the new situation, to new concerns. The definition of piracy, for example, the 1982 Convention defines piracy based on its restrictive character, for example. Another example, innocent passage through the territorial seas, the Basilea Convention
de 1989,
adopted in 1989, and which has to do with extra-frontier transport of dangerous residues and their elimination. It is a convention to which 169 countries in the European Union are part. And this convention and all the events that have been developed based on it introduce huge restrictions to navigation through territorial waters. And in fact, the authorization of the coastal state is required by this convention, which proves that a law, a right as old as that of innocent passage through a territorial sea, can be the object of, as many other rights, can be the object of exemptions. The possible incorporation to the law of the sea of new principles and criteria is also something that's completing and enriching the Convention itself, but without really changing it. The principle of precaution, prevention, the ecosystem approach, even the experience of protected maritime areas itself. I think that all these issues, all these examples, all these new principles are a clear proof of that sort of way of enriching the Convention. It is obvious, and it's been said here today, that the Convention is the supreme law in terms of law of the sea. It is the constitution of our oceans, if you want to say so. But it is not free from being subject to an adaptation to new general requirements, to a better improvement, to a closure or polishing of ambiguations, etc., or to its application and implementation. To say it somehow, and as some years ago, 10, 11 years ago, Professor Bertolio Treves mentioned, the 1982 Convention is something which should not only be considered as a point of idea, as a point of arrival, but also as a point de départ, a point of exit, an exit point, a point to start its adaptation, its better improvement and polishing, its development and its implementation. It's obvious that the Convention doesn't compile everything that has to do with the law of the sea. It doesn't compile all the existing law of the sea currently. But this regulatory dissemination or dispersion brings forward the problem of the correct interpretation by some sectors of the law of the sea, particularly when the new instruments have not duly respected the constitution of the oceans. Anyway, as any regulatory instrument, whether it plays a constitutional role or not, the UN Convention on the Law of the Sea can be subject to revision, to review, to amendment, whatever, which is also specifically included in its final provisions. Today, we could not imagine the calling of a fourth conference of the law of the sea, could we? If we focus on the protection, on the international protection of the marine environment, if we take this into account, I think that the protection of the marine environment clearly shows more and more each day that the sea, as Fernando Vázquez de Menchaca or Hugo Brocio said years ago, that the sea is res communis omnium. Something that the Convention has not duly taken into account when prioritizing territorialization, compartmentalization of the seas, etc. Don't you think that this futurable convention, the product of that futurable meeting of the United Nations to handle the issue of the law of the sea, don't you think that it should look for a better balance between the interests and rights of coastal states and the general interests of the international community? Despite the new trends that we are seeing in this regard, reaching a consensus won't be easy, I think, particularly due to some acquired rights that the states would not be willing to to forget or to reject. That process of amending the Convention would be a long one, and I think it is not a very feasible one, at least now. Despite all this, I think that the UN Convention on the Law of the Sea has been a success per se, beyond any particular case or realization, for example, subjecting the law of the sea to mechanisms for dispute settlement, etc., with its limitations, etc., etc. Despite all this, in my opinion, I think that the Convention should be valued as a whole. This has been similarly expressed by Professor Oxman not so long ago. He was asked about this, and he pointed out that the highest success of the UN Convention on the Law of the Sea was the Convention itself, the UN Convention on the Law of the Sea. It is an instrument which undoubtedly has contributed to and keeps on contributing to the preservation of peace in a planet that, more than the Earth, should be called the ocean. Thank you very much.
El título de mi intervención, de la ponencia,
the title of my speech, of what I want to tell you, is as follows: a model of international law and of the UN Convention on the Law of the Sea. It's not my title, actually. It's a title that was suggested to me by the coordinator of this seminar. I congratulate him and his team, in fact, for organizing this. I thank him as well very much for inviting me so kindly. And the title that I accepted, well, the convention and its pretension of universality and generality, is one that's, well, it's a great pleasure for me to try and tackle it. I'm going to try and develop more or less the ideas that Giuseppe Cataldi and José Manuel Sobrino, also Carlos Domingo, have already more or less put on the table. By the way, it's a great honor to see you once again after such a long time. Anyway, with this convention, with the UN Convention on the Law of the Sea, after many years of work, as Professor Pastor Ridruejo has mentioned, the negotiating delegations and the negotiating parties themselves, Daniel Vignet amongst them, and as I've said, playing a specifically relevant role, they were convinced that with this, with the convention, they would be able to establish a legal scheme and framework which would be generally accepted and which would have a long life, a global treaty that would tackle basically all the aspects regarding utilization, uses, resources in the oceans, etc. Despite of this, the UN Convention on the Law of the Sea took a long time to enter into force, 12 years actually. It entered into force on the 16th of November 1994. And the majority of the contracting parties at the beginning belonged to the developed world. It was significant to mention the important African participation and the scarce European participation, limited basically to Iceland, Malta, and the ex-Yugoslavia. But a few years after its entry into force, or more or less at the same time of that entry into force, ratifications and additions grew up considerably. Union is one of those. And bearing this in mind, also if we use the concept of interested parties, I think that the great absences, to say it somehow, in the convention could be counted just with our fingers, basically. The continent with more non-present countries is one with 15 countries, and also it is significant to mention Iran, Israel, Turkey, which are not part of the convention for different reasons. In Africa, there are 8 countries which are not a party to the agreement. In South America, Colombia, Venezuela, Peru, and particularly also in North America, the United States of America, it's a significant non-presence in the committee, including additions and ratifications by developed countries. The direct cause behind this new situation was no doubt the sort of accommodation or subordination, if you want me to say so, of the original solidarity-based ideology in terms of how to manage common world heritage by the General Assembly of the United Nations. In 1994, the General Assembly passed on an agreement having to do with the 12th part of the 1982 Convention, as you know, and it has to do with that. Today, the UN Convention on the Law of the Sea involves many countries. There are 163 states that are party to it, and the European Union